I'm going to talk about some things that was, basically unsealed regarding the grand jury indictment. But I also want to talk about specifically what the jurors are right now allowed to review in consideration of her innocence or guilt, and what they're not allowed to review. This is something that I have stated in previous videos where people were thinking that it's going to be a slam dunk case, even though there's so much obvious reasonable doubt. What I was saying to people was that it's not necessarily going to be as easy for the jurors as they think, because they're going to be restricted on what they can consider as evidence than what we, as the viewers of this entire case, have researched, have watched, and have observed. We have seen the outside the jury arguments and presentations, and many of the things that was, much of the evidence was voir dired before it was ever presented to the jury, meaning they have to take the experts aside or have evidence discussed outside the presence of the jury. And then even some of the things that was presented, when they decide at the very end of the trial, the evidence that's going to be allowed to go to the jury for their consideration, it's not everything that you have witnessed in trial. And I don't know if people are really paid attention to what was said in the closing, but here's one of the things that they're not allowed to discuss, that I know, especially the people that's been out there with the signs, how long to die in the snow, and then all the communications between the Alberts and each other. And so you have a lot of calls between the Alberts that are very important because it shows an activity of conspiracy. Then you had specific texts and calls between Jen and John. You had specific searches, Google searches from her phone of how long to die in the snow. You had a lot of expert witnesses that talked about those searches and if they were made at 227 or not. And all those activities, the getting rid of the phones, the destroying phones on military property, and the butt dials and all that suspicious activity that just we look at that is just very suspicious. In the instructions of the evidence that they are going to be allowed to consider is not going to include any of the phone activity. None of the calls between the Alberts, none of the Google searches. The only devices and communications that's going to be allowed to be considered is the text messages and the the voicemails, the phone calls between John and Karen alone. And that is so harmful and obviously biased because it completely goes against their ability to prove that there was a conspiracy. Because when you have people who are making phone calls to each other at specific times and then deleting those calls, or claiming that they're not even getting calls when we know they are, and facial recognition secure phones, they're claiming were butt dials, as if you have to go to the bathroom and have your bottom answer the phone. We're talking facial secured phones, facial recognition secured phones. So those were all very important activities because it showed evidence that there was definitely a conspiracy, or at least the ability for them to consider that. But the judge very biasly excluded that evidence. All that time, all the money that she spent on those expert witnesses to counter. Now keep in mind, Lowley was allowed to talk about, in closing, how they were just deluded and just full of garbage, claiming that there was no evidence of a cover-up and that there's just no evidence of that whatsoever. It's all a lie. It's just a bunch of nonsense. And then they turn over the evidence to the jury, and they exclude all the very evidence that does point to suspicious behavior. I don't think people are aware of that. So people are just like shocked and wondering why they haven't already come back with a not guilty. Well, this is part of the reason. So you have expert witnesses that have testified that the accident, it's just ridiculous to even suggest that it would only cause a head injury and it's not consistent. And even their own medical examiners couldn't conclude that it's consistent with a pedestrian being run over. But one of the most important things, and I think Jackson missed this sadly, they have to prove, and I think Jackson should have said, listen, if they cannot prove what they have claimed, they specifically claimed a time of death and a cause of death. And they're bound to that because they presented time and cause of death very specifically, and that's what they prepared for trial to counter, even though they don't have to present anything. So there's a lot of times murder cases you don't even have to have a body, and they can still file a murder case if they think there's enough evidence to prove that a murder happened, even without a body. They may not have the time of death. They may not have the exact cause of death, but they have strong enough evidence that that person is no longer alive and somebody killed them. But in this case, they very specifically gave the specific cause of death was the tail light, and the specific time of death, claiming scientific car EDR data, even though Karen Reed's expert says there was no incidence on that data. But Trooper Paul specifically testified that exactly 12:45 a.m. was the time of the collision. And see, that's very important because the attorney has to explain to the jury that if they cannot prove, they have stated this is the cause of death and this is the time of death, and you have to choose if they have met their evidence of their claim of the time and cause of death. They weren't presenting any other alternate theory of death. It was very specific. 12:45, she ran him over with her car. It was very specific. And then they put on another trooper who talked about specific electronic evidence of her auto-connecting to her Wi-Fi at 12:36 a.m. at John O'Keefe's house. And he also specifically admitted that it's not possible for anyone to have seen her or for her to have been at that residence at 12:45 a.m. So, in fact, his admission to that factor, that the evidence that was never countered by the state, never countered that she didn't auto-connect. They testified that she auto-connected to John O'Keefe's Wi-Fi at 12:36 a.m. But in closing argument, and not objected to by Jackson or Yannetti or the other attorney, Lowley got up there and made a comment that was never presented in the entire trial. Said that she was connected to his Wi-Fi the entire time. And we don't know exactly what's been presented to them other than they said, well, this is what's going to the jury. So they're not going to be allowed to consider the Google search, whether or not that was made, because that's a communication that the only electronic communication that's going to be allowed to be considered is between her and John. That was said by the judge. And so it's not going to be allowed to be considered about how they were calling each other at specific times as evidence that they were acting suspicious. While Lowley gets up there and he gets to say there's no evidence of a cover-up, it's all a bunch of nonsense, because he knows the judge is not going to even allow them to consider the actual evidence that he says doesn't exist, because they've blocked that from going to the jury. And they're not going to be allowed to hear any kind of text messages, even between Brian Higgins and her, how he was texting John at the bar, while John and her were loving on each other. Even the communications between Brian Higgins and John O'Keefe, luring him to the party after she ghosted him in his face, not responding to him. Even those text messages are not allowed to be considered. She blocked all of it. And this is part of the reason why they're really struggling. Because they have to think, well, they're saying it's a cover-up, but we don't have any evidence. They don't have the Google search. They don't have the communications between Brian and John and Brian and Karen, or between the Alberts. Not even the text messages from Proctor to all those other people talking about her like a dog is allowed to go before the jury. And of course, this isn't discussed in the media. Also not discussed in the media is the fact that there was a 71-count federal indictment against multiple Massachusetts state troopers for a bribery scheme, conspiracy, falsifying records because they were issuing fake CDL licenses. But what they don't mention in that case that was filed in January 2024 was that the people receiving that benefit of giving gifts and getting licenses on false pretenses, knowing that they're falsifying records if they don't pass, they were giving such benefits to fellow state troopers and police officers across the state of Massachusetts. And we don't even know, because those names were redacted, that appears to be used as witnesses instead of filing charges on them also. So you have police officers and troopers still in power who are part of that scandal. It's called the Golden Treatment Gate. Golden treatment were in the text messages. The very types of text messages that this jury's not going to be allowed to review, that they were offering gifts to Trooper Proctor, because none of those communications were allowed to be considered by the jury. And you don't hear any objections from Yannetti or Jackson on their exclusion of that. Now, maybe they did, sidebar or whatever, and they just have to reserve that for appeal if they need an appeal. None of that. None of the communications, that horrible things Proctor said. Now, keep in mind, the jury shall remember those parts of the trial, but when they're instructed, they're not allowed to consider that as part of the evidence of her innocence or guilt. I told people this. I told them that they're going to be blocking what the jurors can consider as evidence, because they are in fact biased. And this is how, despite what kind of evidence that people may have of innocence, this is how people get convicted that are innocent across our nation. And it's up to the people to demand that they don't get to have this discretion. If there's any kind of evidence, we have to demand better laws to protect the accused. They shouldn't have the ability to block such evidence. They shouldn't have that discretion. There should be a constitutional right of every single defendant to present evidence when it points to suspicious behavior of somebody else who could be involved in the act of what they're accused of. There has to be a law to mandate that and removal of any judge that fails to follow that law. There are so many people out there right now that have driven, who have flown from different states, even different countries, demanding change because they've seen so much that the jury is not even allowed to consider. But I'm begging people to please share this so that people understand what the jurors do not have and are not allowed to use in consideration. People are like, why aren't they coming back with not guilty already? Yannetti, if you saw his comments to the media the day before he presented the last 3 witnesses, very sadly cut her off. He said that he was so confident that he won, he wasn't going to call the police officer who saw Brian Higgins at the Sallyport at her car for a very long time. He wasn't going to call that officer who was willing to stand up and testify that Higgins lied. And not only Higgins, but other officers. They know. They saw Higgins at that car. And then they also cut off the other people who was attacked by that dog. They cut them off. No, not going to bother with calling any other people. Nah, we won. That was the most egregious mistake and shorting of her. Because when you have these jurors who have to accept that this is an attack on all of these police, and they've excluded much evidence that proves there was a conspiracy, while Lally's bragging that there's no evidence of any kind of conspiracy because he knows the judge is going to exclude all the evidence that can be used to prove that there was a conspiracy. This is tyranny. But please, please share this video so people can understand, or at least discuss it with other people. Do your own video, but please, something. Share this. This is why there wasn't a swift not guilty on all counts. They have been restricted. They can't discuss, they can't even consider the how long to die in the cold. They cannot consider all the deleted calls, the butt dials, the text messages from Proctor talking about her, hoping she dies, and talking about her horribly to other people. They can't consider the communications to Proctor of promises of gifts. And this is while a case has been filed of a 71 count against state troopers who were giving benefits and taking bribes from other state troopers, and cops take care of my trooper friend. Promising gifts in those text messages in that case. And sadly, I don't even believe that her lawyers brought the case up. May not even known about the case. But the media knows about that case. And I have a video that I did today while I was watching in the stream of chat, and I'm trying to share about that case, and NBC 10 Boston blocked those comments, just trying to make other people aware of that case. They're very calculated to protect the law enforcement in place and the corrupt system. NBC 10 Boston, as a matter of fact, did not reveal that the judge was smirking and being smirky in the courtroom. And then Karen, she's just had it at this point. She did kind of look behind her and just kind of laugh like it was just so ridiculous what this judge was saying. And she admonished her openly. And that no sooner happened than NBC 10 Boston makes a video to point out to the world that the judge just, she's talked bad to Karen because she's laughing in the courtroom. They're so biased. They didn't report how Stephen Scanlon knew about things that he couldn't have known about, the private investigator who is the one who started a third-party culprit because he knows the Alberts and other people. They omitted this case that shows that there is a very serious corrupt system going on in the state of Massachusetts. They don't want anybody to know about that 71 count charges against state troopers where cops across the state of Massachusetts and other troopers were, giving bribes to state troopers issuing licenses. They don't want people to know about that because they're trying to make a mockery of her to even suggest that there was a conspiracy. While Lowley's bragging and it's a bunch of nonsense about the conspiracy, the very evidence of their suspicious behaviors was blocked. And I don't think people realize that. Because I have so many people that I see that's confused and they don't understand, and they're all thinking there's going to be a swift not guilty. Did you listen closely to what the judge said? That they're going to be allowed to review the instructions. And an interesting thing also, NBC 10 Boston channel, as soon as they rested and it was going to go to the deliberations, they cut off the stream. They did not cover the instructions argument. They did not want the public to see that. And you know why? Because it was in that hearing that they said what they're going to be allowed to review. The instructions. But I don't know if people paid attention when they were given instructions. And so the question they asked today was about the CERT report on the search. And of course, that's not in the evidence. She said, no, what you have is what you're going to get. So here's another problem. Because they're so shady to just basically, after Lowley spends half of the trial defending those, calling and spending the taxpayers' money on all these experts to defend these other witnesses, they presented the evidence about those text messages and those Google searches, and yet that wasn't allowed to go before the jury. Those communications were not allowed to be reviewed in the consideration of her innocence or guilt. She very specifically said the only communications. So, did the defense even get to look at what they actually have? Did they even get to see what's actually going to the jury? Because here is where you go back to the grand jury indictment. 100 pages of documents related to the Karen Read case were released days ahead of her trial. They didn't even get to know in time to prepare for trial. So in what was done at her grand jury indictment, and this was from a request of documents by the Boston Globe, they would only unseal some of the documents. How dare they? How dare they hide what they're doing to the media and to the public? And why didn't NBC 10 Boston request that? But the Boston Globe did. But they refused to release. They released some of it. It's just egregious. It's absolute tyranny. So the majority of the witnesses who testified before the grand jury were not recipient witnesses to any of the events in question. They were called for the purpose of testifying to promote an irrelevant bad character and propensity evidence prejudicing the jury against Miss Read, misleading the grand jury, confusing the issues, wasting time. Not a single witness testified that they observed her striking him with the vehicle or injuring him in any way or drive anything erratically on the night in question. Keep in mind, she was indicted very early on. They didn't have any of the tests back at that time. It was all bad it was just attacking her character. There has to be laws passed on grand jury procedures, on not allowing to hide evidence in any state across America. There has to be rights to the accused. And you can't just do things and then hide it. When they found out about the other people who had been attacked by their dog, what'd they do? They filed to impound the animal control records and committed criminal suborning of perjury by putting the Alberts on the stand to say that that dog never attacked anybody. When they have hospital records and reports. They criminally suborned perjury, knowing what they were saying was absolutely a lie. And I'm just like, people, this is a situation that can be defeated. There's just certain things that have to be done. One, a number of people must file a formal complaint to the Massachusetts Judicial Removal Commission about this judge who, knowing that there was hospital records showing that there was attacks on other people by this dog, did collude with Adam Lally to criminally suborn perjury, knowing the Bar Association ethics do not allow such behavior, nor does the laws on exculpatory evidence to allow them to testify that there was never any accusations of dog bites on other people. Those are crimes. And to demand her removal. And second, to file a Bar Association complaint against Adam Lally for suborning of perjury by knowing there were hospital records that those dogs sent people to the hospital, and he put those people on the stand to say there was never any accusation that that dog ever bit anybody. And those are clear violations of attorney ethics. Those rules that lawyers have to comply by. And that's not even talking about the state and federal crimes. To suppress evidence of crimes. Suppressing evidence of crimes is knowing somebody's committing perjury, and instead of prosecuting them, you hide that evidence. He not only suppressed that evidence, he enjoined the criminal behavior by suborning such perjury. People have to take these very specific actions and demand to the governor, to the attorney general, to the FBI, to the Department of Justice. I mean, showing up and standing out there with signs and making a presence, that's great. But what really is needed to really bring forth fruit, other than just some attention on a situation that in time will just be like, oh, yeah, I remember that. They must take legal strategic steps to specifically protest and petition the Bar Association, the Judicial Removal Commission. I showed a case recently where a judge was removed to hold these people accountable, to demand also someone needs to file a case in federal court demanding that the FBI and the Department of Justice may not redact the names of police officers and state troopers who are committing criminal acts just because they chose not to charge them, because they want to use them as witnesses in their federal case. They must remove those people from power. And when those same people allowed to stay in power, when evidence is that they are a part of a criminal scandal, that the defendants in a case, if there's any officers in that scandal or troopers in that scandal that have testified in this case, Karen Read has a right to know. Because that's impeachable. That's something that you would present to impeach them. And that's exculpatory evidence that she has a constitutional right to. But right now, when I present this, these media outlets are blocking people from knowing about this. So I am begging you to please share this video and share it with those people who are out there wanting to take action. Please organize a petition to the Bar Association very specifically that Adam Lally suborned perjury with the Alberts by putting them on the stand to say that there was no evidence or any incident of the dog attacking anybody. There was it got in a fight with another dog, so that's why they got rid of it. No, it specifically attacked other people, sending them to the hospital, and there are records of that. And sadly, her own attorneys did not put those people on the stand because he felt he won the case, he told the media. And then for the judge to impound those records, so in aiding and abetting Adam Lally to suborn perjury, to not let the